This Very good. But it's still been and they deny it. They'll come for the gentleman over there. The gentleman over there will say, no, 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 they're free. It's unsteady. Equally constant. Yes. Yes. I said, please cross. Check, check. Audio check. Check, check. Audio check. Mic check. Bukla Road is like the Gaza strip of. Check, check, check. in the crease.
BCA. Check, mic check. 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 1, 2, 3, 4, 5, 6. Audio check. Check.
1501 for judgment. I'll read out the essence of the judgment. There are three judgments of this court. One authored by the Chief Justice for himself, Justice Gavai and Justice Suryakant. There is a concurring opinion authored by Justice Sanjay Kishan Kaul. Justice Sanjeev Khanna has concurred with both the judgments. The reference before the Constitution bench raises the following questions for determination. A, whether the provisions of Article 370 were temporary in nature or whether they acquired a status of permanence in the Constitution. B, whether the amendment to Article 367 and exercise of the power under Article 371D was to substitute the reference to the Constituent Assembly of the state referred to in Clause 3 of Article 370 by the words Legislative Assembly of the state is constitutionally valid. C, whether the entire Constitution of India could have been applied to the state of Jammu and Kashmir in exercise of the power under Article 370, Clause 1, bracket D. D, whether the abrogation of Article 370 by the President in exercise of the power under Article 370, Clause 3 is constitutionally invalid in the absence of a recommendation of the Constituent Assembly of the state of Jammu and Kashmir as mandated by the proviso to Clause 3. E, whether the proclamation of the Governor dated 20 June 2018 in exercise of power conferred by Section 92 of the Constitution of Jammu and Kashmir and the subsequent exercise of power on 21 November 2018 under Section 53(2) of the Constitution of Jammu and Kashmir to dissolve the Legislative Assembly are constitutionally valid. F, whether the proclamation which was issued by the President of India under Article 356 of the Constitution on 19 December 2018 and the subsequent extensions are constitutionally valid. G, whether the Jammu and Kashmir Reorganization Act 2019, by which the state of Jammu and Kashmir was bifurcated into two union territories, the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh, is constitutionally valid, bearing in mind, 1, the first proviso to Article 3, which requires that a bill affecting the area, boundaries, or name of a state has to be referred to the legislature of the state for its views, and 2, the second proviso to Article 3, which requires the consent of the state legislature for increasing or diminishing the area of the state of Jammu and Kashmir, or altering the name of the boundary of the state before the introduction of the bill in Parliament. H, whether during the tenure of a proclamation under Article 356, and when the Legislative Assembly of the state is either dissolved or is in suspended animation, the status of the state of Jammu and Kashmir as a state under Article 1(3)(a) of the Constitution and its conversion into a union territory under Article 1(3)(b) constitutes a valid exercise of power. I'll now read out our conclusions under different heads. Whether the proclamation issued under Article 356 of the Constitution of India and Section 92 of the Constitution of Jammu and Kashmir is constitutionally valid. We have held that this court need not adjudicate on the validity of the proclamations because, 1, the pleadings of the petitioners in the writ petitions indicate that their principal challenge is to the abrogation of Article 370 and whether such an action could have been taken during Precedent's rule. And 2, even if this court holds that the proclamation could not have been issued under Article 356, there would be no material relief which can be given in view of the fact that Precedent's rule was revoked in the state of Jammu and Kashmir on 31st October 2019. Further, the petitioners have assailed the specific actions which were taken when the proclamation was in force on the ground that those actions breached the constitutional limitations on the exercise of power after a proclamation under Article 356 is issued. These substantive challenges, which form the fulcrum of the case of the petitioners, have been considered. Next issue, whether there are limitations on the exercise of power by the President or Parliament under Article 356. We have held that there are limitations on the power which can be exercised by the Union government in the state when a proclamation under Article 356 is in operation. We have reached the conclusion on the following grounds. A, the majority in S.R. Bommai the 9-judge bench decision, held that the actions taken by the President after issuing a proclamation are subject to judicial review. However, the learned judges adopted slight variations on the standard needed to be applied by the court to test the validity of the exercise of power by the President after the issuance of the proclamation. Justice Sawant applied the standard of whether the exercise of power was mala fide or palpably irrational. Justice Reddy observed that the advisability and necessity of the action must be borne in mind by the President. 2. This bench, sitting in a combination of 5 judges, is bound by the decision of the majority in S.R. Bommai on the issue. We also undertook a textual and purposive reading of Article 356 in particular and Part 18 as a whole. We hold that there are limitations on the power exercisable after a proclamation under Article 356 is issued. The following are our reasons. First, the thread that runs through Part 18 of the Constitution, when read as a whole, is that differing levels of executive and legislative power are required to handle an emergency under Article 352 and under Article 356. This principle applies to the exercise of power when a proclamation under Article 356 is in force. Second, Article 356(1) states that the President may, by a proclamation, assume or declare the powers stipulated in clauses A, B, and C of Article 356(1). The powers stipulated in clauses A, B, and C of Article 356(1) are not automatically invoked when a proclamation is issued under Article 356. Third, Article 356(1)A does not opt for an all or none formula. The phrase all or any does not indicate that the union government can exercise a part of the functions of the state government and the state government can exercise the remaining, because the suspension of the state government is an automatic consequence of the proclamation under Article 356. It rather indicates that the scope of the power exercised by the union government must depend on the circumstances for issuing the proclamation. Fourth, clauses A, B, and C of Article 356(1) grant the President independent powers. However, the power provided under Clause C is broad enough to encapsulate the power of the President to assume functions under Clause A and declare under Clause B that the powers of the legislature of the state shall be exercisable by Parliament. Fifth, the principle underlying Article 356(1)(c) is that the exercise of power by the President must be desirable or necessary to give effect to the objects of the proclamation. The commonality in both the necessity and desirability standard is that the exercise of power must have a reasonable nexus with the object of the proclamation. Thus, the principle which runs through Article 356(1)(c) and which also guides the exercise of power under Article 356(1)(a) is that the exercise of power must have a reasonable nexus with the object of the proclamation. And sixth, when a proclamation under Article 356 is in force, there are innumerable decisions which are taken by the union government on behalf of the state government for the purpose of day-to-day administration. Every decision and action taken by the union executive on behalf of the state is not subject to challenge. Opening up challenge to every decision would lead to chaos and uncertainty. It would in effect put the administration in the state at a standstill. Therefore, the following standard is laid down to assess actions under Article 356 after the proclamation has been issued. A, the exercise of power by the President under Article 356 must have a reasonable nexus to the object of the proclamation. B, the person challenging the exercise of power must prima facie establish that it is a mala fide or extraneous exercise of power. After a prima facie case is made, the onus shifts to the union to justify that the exercise of power had a reasonable nexus with the object of the proclamation. And C, the exercise of power by the President for everyday administration of the state is not ordinarily subject to judicial review. The argument of the petitioners that the union government cannot take actions which have irreversible consequences when a proclamation under Article 356 is in force is not accepted. The power of the legislature of the state under Article 357 to repeal or alter or amend a law enacted by Parliament in exercise of the power of the legislature of the state must be read in the context of the amendment introduced by the Constitution, 42nd Amendment Act 1976. Before the amendment, the law to the extent of incompetency would automatically cease to exist after a buffer period and actions done were expressly saved. However, an express repeal by the competent legislature is required for the law to cease to exist after the amendment. The repealing statute would, in such case, make provisions for actions taken during the subsistence of the legislation. The observations in Krishna Kumar Singh on whether the consequence of an ordinance can subsist even after the ordinance ceases to exist cannot be transposed to interpret the limits of Article 356, because an ordinance which has the effect of a law by its very nature has a limited life. The argument of the petitioners that Parliament can only assume the lawmaking powers of the legislature of the state when the proclamation under Article 356 is issued is not accepted. The purpose of Article 357 is to ensure that while exercising the powers of the legislature of the state, pursuant to a declaration under Article 356(1), Parliament, or as the case may be, the President, are not impeded by an absence of competence which would have impeded the exercise of a similar power in the absence of a proclamation under Article 356. Further, Article 357 does not contain a non-obstante provision which overrides Article 356. To interpret Article 357(1) as a restriction on Article 356(1)(b would be to read in a restriction which the plain terms of the Constitution do not provide. As held above, the exercise of power after a proclamation under Article 356 is issued is subject to judicial review, and immunity from judicial scrutiny does not attach to the exercise of constitutional powers of the legislature of the state. The court, while judicially reviewing the exercise of power, can determine if the exercise of the constitutional power of the legislature of the state by Parliament has a reasonable nexus with the object sought to be achieved by the proclamation. The next issue is whether Jammu and Kashmir retained an element of sovereignty or internal sovereignty when it joined the Union of India. We have held that the state of Jammu and Kashmir did not retain an element of sovereignty when it joined the Union of India. We have arrived at this conclusion for the following reasons. First, paragraph 8 of the instrument of accession executed by Maharaja Hari Singh provided that nothing in the instrument would affect the continuance of the sovereignty of the Maharaja in and over the state. Second, on 25 November 1949, a proclamation was issued for the state of Jammu and Kashmir by Yuvraj Karan Singh. The declaration in this proclamation that the Constitution of India would not only supersede all other constitutional provisions in the state which were inconsistent with it, but also abrogate them, achieves what would have been attained by an agreement of merger. With the issuance of the proclamation, paragraph 8 of the instrument of accession ceased to be of legal consequence. The proclamation reflects the full and final surrender of sovereignty by Jammu and Kashmir through its sovereign ruler to India, to her people who are sovereign. Third, neither the constitutional setup nor any other factors indicate that the state of Jammu and Kashmir retained an element of sovereignty. The Constitution of Jammu and Kashmir was only to further define the relationship between the Union of India and the state of Jammu and Kashmir. The relationship was already defined by the instrument of accession, the proclamation by Yuvraj Karan Singh in November 1949, and more importantly, by the Constitution of India. Fourth, there is a clear absence in the Constitution of Jammu and Kashmir of a reference to sovereignty. In contrast, the Constitution of India emphasizes in its preamble that the people of India resolve to constitute themselves or to constitute India into a sovereign, socialist, secular, democratic republic. Fifth, that the state of Jammu and Kashmir became an integral part of the Union of India is evident from Articles 1 and 370 of the Indian Constitution. It is reiterated in Section 3 of the Constitution of Jammu and Kashmir, which is unamendable. Sixth, the preamble of the Constitution of Jammu and Kashmir, Sections 3, 5, and 147 of the State Constitution, coupled with Article 1 of the Constitution of India, read with the first schedule, as well as Article 370, indicate in no uncertain terms that a system of subordination as understood by the definition of sovereignty exists by which the state is subordinate to the Indian Constitution first and only then to its own constitution. Seventh, all states in the country have legislative and executive power, albeit to differing degrees. The Constitution accommodates concerns specific to a particular state by providing for arrangements which are specific to that state. Articles 371A to 371J are examples of special arrangements for different states. This is a feature of asymmetric federalism, like Article 370, which became applicable to Jammu and Kashmir on the adoption of the Constitution. The state of Jammu and Kashmir does not have internal sovereignty which is distinguishable from the powers and privileges enjoyed by other states in the country. And eighth, the limited question before the Constitution bench in its decision in Premnath Call was whether the monarch held plenary legislative powers after the Constitution of India as it applied to Jammu and Kashmir was adopted in the state, but before the Constitution of Jammu and Kashmir was adopted. A decision is an authority for the proposition which it decides. The question whether the state of Jammu and Kashmir retains sovereignty upon integration with the dominion of India did not arise in that case. The next issue which we have addressed is the challenge to Constitutional Order 273, CO 273. To answer this issue, we had to decide on two issues. One, whether Article 370 is a temporary provision, and two, the effect of the dissolution of the Constituent Assembly of Jammu and Kashmir on the scope of powers under Clause 3 of Article 370. We have held that Article 370 is a temporary provision on a reading of the historical context in which it was included. Article 370 was introduced to serve two purposes. First, the transitional purpose, to provide for an interim arrangement until the Constituent Assembly of the state was formed and could take a decision on the legislative competence of the Union on matters other than the ones stipulated in the instrument of accession and ratify the Constitution. And second, a temporary purpose, an interim arrangement in view of the special circumstances because of the war conditions in the state. C. We have held that a textual reading of Article 370 also indicates that it is a temporary provision. For this purpose, we have referred to the placement of the provision in Part 21 of the Constitution, which deals with temporary and transitional provisions, the marginal note to the provision, which states temporary provisions in respect to the state of Jammu and Kashmir, and a reading of Articles 370 and 1, by which the state became an integral part of India upon the adoption of the Constitution. D. On the second question of the effect of the dissolution of the Constituent Assembly of Jammu and Kashmir on the scope of powers under Clause 3 of Article 370, we have held that the power of the President of India under Article 370, Clause 3, to issue a notification declaring that Article 370 ceases to exist, subsists even after the dissolution of the Constituent Assembly of Jammu and Kashmir for the following reasons. First, the proviso to Article 373, that is Clause 3, encapsulates the process by which the Indian states could ratify the Constitution of India. The ruler of each Indian state had to issue a proclamation ratifying the Constitution on the recommendation of the Constituent Assembly, where such body existed. In states where the Constituent Assembly was not convened by then, the ruler of the state had to issue a proclamation accepting the Constitution. When a Constituent Assembly was convened in those states, the Constituent Assembly could make a recommendation for the modification of the Constitution as it applied to the state, and such a recommendation would be earnestly considered, into inverted commas, earnestly considered by the Union. The words recommendation of the Constituent Assembly referred to in Clause 2 shall be necessary before the President issues a notification, as it appears in the proviso to Article 370, Clause 3, and must be read in this context. Thus, the recommendation of the Constituent Assembly to begin with was not binding on the President. Second, at the time of the framing of the Constitution of India, it was obviously within the contemplation that the Constituent Assembly of Jammu and Kashmir was formed for framing the Constitution for the state. It was not intended to be a permanent body, but a body with a specific remit and purpose. The power conferred by the proviso to Article 370, Clause 3 was something which would operate in a period of transition when the Constituent Assembly of Jammu and Kashmir was formed and was in existence pending the drafting of the state constitution. Third, when the Constituent Assembly of Jammu and Kashmir ceased to exist, only one of the special circumstances for which the provision was introduced ceased. However, the other circumstances, that is the special circumstances because of the situation in the state of Jammu and Kashmir, for which Article 370 was introduced, subsisted even after the Constituent Assembly ceased to exist. This is recognized by the judgment of the Constitution Bench in Sampat Prakash. Fourth, the effect of the President declaring under Clause 3 of Article 370 that Article 370 ceases to exist is that the provisions of the Constitution which apply to every state in the first schedule would equally apply to the state of Jammu and Kashmir. Articles 370(1)(d) and 370(3) were introduced with the purpose of enhancing constitutional integration and not for the disintegration. So, the power under Article 370(1)(d) and Article 370 Clause 3, even when exercised to its fullest extent, does not freeze the system of integration contemplated by Article 370, but is rather intended to enhance constitutional integration between the Union and the state of Jammu and Kashmir. Holding that the power under Article 370 Clause 3 cannot be exercised after the dissolution of the Constituent Assembly would lead to the freezing of the process of integration, contrary to the purpose of introducing the provision. And 5, if the contention of the petitioners on the interpretation of Article 370 vis-a-vis the dissolution of the Constituent Assembly is accepted, then Article 370 Clause 3 would become redundant and would lose its temporary character. The President, while deciding if the power under Article 370 Clause 3 must be exercised, determines if the special circumstances which warranted a special solution in the form of Article 370 have ceased to exist. This is a policy decision which completely falls within the realm of the executive. The court cannot sit and appeal over the decision of the President of India on whether the special circumstances which led to the arrangement under Article 370 have ceased to exist. However, the decision is not beyond the scope of judicial review. It is settled law that the exercise of executive power can be challenged on the ground of malafide. The slew of constitutional orders issued by the President under Article 370(1)(d), applying various provisions of the Constitution and applying provisions with modification, indicate that over the course of the last 70 years, the Union and the state have, through a collaborative exercise, constitutionally integrated the state of Jammu and Kashmir with the Union. This is not a case where only Articles 1 and Article 370 of the Constitution were applied to the state of Jammu and Kashmir, and suddenly, after 70 years, the entire Constitution was being made applicable. The continuous exercise of power under Article 370, Clause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President in exercise of the power under Clause 3 of Article 370 is a culmination of the process of integration. Thus, we do not find that the President's exercise of power under Clause 3 of Article 370 was malafide. Having concluded that the power under Article 370 Clause 3 subsisted even after the dissolution of the Constituent Assembly, we have held that the exercise of power by the President to issue CO 273 is a valid exercise of constitutional power. The next issue is the challenge to CO 272 on the ground that the power under Article 370(1)(d) cannot be issued to apply all the provisions of the Constitution to the state of Jammu and Kashmir. We have held that all provisions of the Constitution can be applied to Jammu and Kashmir through the exercise of power under Article 370(1)(d). The power under Article 370(1)(d) can be used to apply one provision, more than one provision, an entire part of the Constitution, or all the provisions of the Constitution, that is the entire Constitution. The provision does not make a distinction between one or all provisions of the Constitution. Non-application of mind cannot be claimed merely because CO 272 applies all provisions of the Constitution to Jammu and Kashmir in one go. The next issue is the challenge to CO 272 on the ground that the President could not have secured the concurrence of the Union government under the second proviso to Article 371D. We hold that the President seeking the concurrence of the Union government instead of the government of the state to issue CO 272 is not invalid because, first, the effect of applying all the provisions of the Constitution to the state of Jammu and Kashmir through the exercise of power under Article 371D is the same as an exercise of power under Article 370, Clause 3, notifying that Article 370 shall cease to exist. That is, all provisions of the Constitution of India will apply to the state of Jammu and Kashmir, except for the fact that the former can be reversed while the latter, namely under Clause 3, cannot. Second, consultation and collaboration between both the units will only be necessary where the application of the provisions of the Indian Constitution to the state would require amendments to the state constitution, because the purpose of the requirements of consultation and collaboration is for the smooth functioning of governance in the state and to ensure that the provisions of the Constitution of Jammu and Kashmir are not inconsistent with the provisions of the Constitution of India. Third, since the effect of applying all the provisions of the Constitution of Jammu and Kashmir, to Jammu and Kashmir through the exercise of the power under Article 371D is the same as issuing a notification under Article 370, Clause 3, which the President has the power to unilaterally issue, the principle of consultation and collaboration are not required to be followed. Fourth, the exercise of power is mala fide only if power was exercised with an intent to deceive. Deception can only be proved if the power which is otherwise unavailable to the authority or body is exercised, or if the power that is available is improperly exercised. Since the concurrence of the state government was not required for the exercise of power under Article 370(1)(d) to apply all provisions of the Constitution to the state, the President securing the concurrence of the Union of India on behalf of the state government is not mala fide. The next issue is the challenge to CO 272 on the ground that it is ultra vires Article 371D because it modifies Article 370. We have held that the modification by CO 272 to Article 367 as it applies to Jammu and Kashmir had the effect of amending Article 370 and is thus ultra vires Article 370(1)(d). We have reached this conclusion for the following reasons. First, recourse must be had to the procedure contemplated by Article 370, Clause 3, if Article 370 is to cease to operate or is to be amended or modified in its application to the state of Jammu and Kashmir. No other procedure may be utilized to amend Article 370. Second, the rule of interpretation that a power under a statute must be exercised in accordance with the provisions of that statute and in no other manner is undoubtedly applicable to the Constitution. Third, from precedent, including Shankari Prasad Singh, Sajjan Singh, Kyoto Holohan, and Rajendra Shah, it emerges that the following aspects are of significance when assessing whether a change has been made to a provision of the Constitution. One, a change may be either in terms of or in its effect. Two, a change can be said to have been made even if the language of the concerned provision is not directly amended by adding, subtracting, or modifying the language. This is a change in effect. And three, if the effect of an amendment is to change a provision, such effect must be significant or appreciable. And four, the substance of a change is more important than its form. Second, an assessment of whether a constitutional order amounts to a modification and consequently whether the procedure under Article 370, Clause 1 or under Article 370, Clause 3 ought to have been followed depends on this standard. Third, the effect of a provision of law is as important as its form. While the change sought to be made by paragraph 2 of CO 272 may appear to be a modification or amendment of Article 367 at first blush, its effect is to amend Article 370 itself. CO 272 changes the language to the proviso to Article 370, Clause 3 in two ways. First, it changes the recommending body from the Constituent Assembly to the Legislative Assembly. And second, it makes a new arrangement at variance with that specific Constituent Assembly. Both these changes are not insignificant because they modify the essential character of the proviso by substituting a particular type or kind of body with another type or kind entirely. Fourth, while the interpretation clause, namely Article 367, can be used to define or give meaning to particular terms, it cannot be deployed to amend a provision by bypassing the specific procedure laid down for its amendment. This would defeat the purpose of having a procedure for making an amendment to the Constitution of India. Fifth, the consequence of permitting amendments through the circuitous manner would be disastrous. Many provisions of the Constitution would be susceptible to amendments which evade the procedure stipulated by Article 368 or other provisions. Sixth, the previous constitutional orders which modified Article 370 through Article 367 were clarificatory and consequential. They did not have the effect of amending Article 370. We have therefore held as ultra vires the amendments which were made to Article 370, Clause 3 by taking recourse to Article 367. G, the status of the Constitution of Jammu and Kashmir. The gaps left by the non-application of some parts of the Constitution of India were filled by the Constitution of the state. After the abrogation of Article 370, as it stood before the issuance of CO 272 and CO 273, and the application of the entirety of the Constitution of India to the state, the Constitution of the state does not fulfill any purpose or serve any function. Hence, the implicit but necessary consequence of the application of the Constitution of India in its entirety to the state of Jammu and Kashmir is that the Constitution of the state is inoperative. On the validity of Parliament's exercise of power under the first proviso to Article 3, this is what we have said. A 5-judge bench of this court in Babulal Parate held that the views expressed by the legislature of the state under the proviso to Article 3 are not binding on Parliament. If the views of the state legislature were binding on Parliament, which is not the case, there would be scope for debate on whether Parliament, in exercise of its powers under Article 356(1)(b), could have substituted its views for the views of the Legislative Assembly of the state. However, the views of the legislature of the state are not binding on Parliament in terms of the first proviso to Article 3. The views of the legislature of the state under the first proviso to Article 3 are recommendatory to begin with. Thus, Parliament's exercise of power under the first proviso to Article 3 is valid and not mala fide. The next issue is on the validity of the suspension of the second proviso to Article 3 as applicable to Jammu and Kashmir. When the reorganization bill was introduced, that is on 5 August 2019, the second proviso to Article 3 as it applied to the state of Jammu and Kashmir ceased to exist because of CO 272. Thus, the issue of whether the second proviso to Article 3 could have been suspended in exercise of the power under Article 356(1)(c) does not survive. The next issue is the validity of the Jammu and Kashmir Reorganization Act 2019. The Solicitor General, appearing for the Union of India, submitted that statehood will be restored to Jammu and Kashmir and that its status as a union territory is temporary. The Solicitor General submitted that the status of the Union Territory of Ladakh will not be affected by the restoration of statehood to Jammu and Kashmir. In view of the submission made by the Solicitor General that statehood would be restored of Jammu and Kashmir, we do not find it necessary to determine whether the reorganization of the state of Jammu and Kashmir into 2 union territories of Ladakh and Jammu and Kashmir is permissible under Article 3. The status of Ladakh as a union territory is upheld because Article 3A, read with explanation 1, permits forming a union territory by separation of a territory from any state. This court is alive to the security concerns in the territory. Direct elections to the legislative assemblies, which is one of the paramount features of representative democracy in India, cannot be put on hold until statehood is restored. We direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30 September 2024. Restoration of statehood shall take place at the earliest and as soon as possible. The question of whether Parliament can extinguish the character of statehood by converting a state into 1 or more union territories in exercise of power under Article 3 is left open. In an appropriate case, this court must construe the scope of powers under Article 3 in light of the necessary effect of converting a state into union territories, which is that autonomy would be diminished, the historical context for the creation of federating units, and its impact on the principles of federalism and representative democracy. In view of the above discussion, the following are the conclusions. A. The state of Jammu and Kashmir does not retain any element of sovereignty after the execution of the instrument of accession and the issuance of the proclamation dated 25 November 1949, by which the Constitution of India was adopted. The state of Jammu and Kashmir does not have internal sovereignty, which is distinguishable from the powers and privileges enjoyed by other states in the country. Article 370 was a feature of asymmetric federalism and not sovereignty. B. The petitioners did not challenge the issuance of the proclamations under Section 92 of the Jammu and Kashmir Constitution and Article 356 of the Indian Constitution until the special status of Jammu and Kashmir was abrogated. The challenge to the proclamations does not merit adjudication because the principal challenge is to the actions which were taken after the proclamation was issued. C. The exercise of power by the President after the proclamation under Article 356 is issued is subject to judicial review. The exercise of power by the President must have a reasonable nexus with the object of the proclamation. The person challenging the exercise of power must prima facie establish that it is a mala fide or extraneous exercise of power. Once a prima facie case is made, the onus shifts to the Union to justify the exercise of such power. D. The power of Parliament under Article 356(1)(b) to exercise the powers of the legislature of the state cannot be restricted to lawmaking power, thereby excluding non-lawmaking power of the legislature of the state. Such an interpretation would amount to reading in a limitation into the provision contrary to the text of the article. E. It can be garnered from the historical context for the inclusion of Article 370 and the placement of Article 370 in Part 21 of the Constitution that it is a temporary provision. F. The power under Article 370, Clause 3 did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir. When the Constituent Assembly was dissolved, only the transitional power recognized in the proviso to Article 370, Clause 3, which empowered the Constituent Assembly to make its recommendations, ceased to exist. It did not affect the power held by the President under Article 370, Clause 3. G. Article 370 cannot be amended by exercise of power under Article 370(1)(d). Recourse must have been taken to the procedure contemplated by Article 370, Clause 3, if Article 370 is to cease to operate or is to be amended or modified in its application to the state of Jammu and Kashmir. Paragraph 2 of CO 272, by which Article 370 was amended through Article 367, is ultra vires Article 370, Clause 1, Clause D, because it modifies Article 370 in effect without following the procedure prescribed to modify Article 370. An interpretation clause cannot be used to bypass the procedure laid down for amendment. H. The exercise of power by the President under Article 370(1)(d) to issue CO 272 is not mala fide. The President in exercise of power under Article 370, Clause 3 can unilaterally issue a notification that Article 370 ceases to exist. The President did not have to secure the concurrence of the government of the state or union of the union government acting on behalf of the state government under the second proviso to Article 370(1)(d) while applying all the provisions of the Constitution to Jammu and Kashmir, because such an exercise of power has the same effect as an exercise of power under Clause 3 of Article 370, for which the concurrence or collaboration with the state government was not required. I. Paragraph 2 of CO 272 issued by the President in exercise of power under Article 370(1)(d), applying all the provisions of the Constitution of India to the state of Jammu and Kashmir is valid. Such an exercise of power is not mala fide, merely because all the provisions were applied together without following a piecemeal approach. J. The President had the power to issue a notification declaring that Article 370, Clause 3 ceases to operate without the recommendation of the Constituent Assembly. The continuous exercise of power under Article 370, Clause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President under Article 370, Clause 3 is a culmination of the process of integration and as such is a valid exercise of power. Thus, CO 273 is valid. K, the Constitution of India is a complete code for constitutional governance. Following the application of the Constitution of India in its entirety to the state of Jammu and Kashmir by CO 273, the Constitution of the state of Jammu and Kashmir is inoperative and is declared to have become redundant. L, the views of the legislature of the state under the first proviso to Article 3 are recommendatory. Thus, Parliament's exercise of power under the first proviso to Article 3 under the proclamation was valid and not mala-fide. M, the Solicitor General stated that the statehood of Jammu and Kashmir will be restored, except for the carving out of the Union Territory of Ladakh. In view of the statement, we do not find it necessary to determine whether the reorganization of the state of Jammu and Kashmir into two Union Territories of Ladakh and Jammu and Kashmir is permissible under Article 3. However, we uphold the validity of the decision to carve out the Union Territory of Ladakh in view of Article 3A, read with Explanation 1, which permits forming a Union Territory by separation of a territory from any state. And we direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30 September 2024. Restoration of statehood shall take place at the earliest and as soon as possible.
So I begin from a different way from the history of Kashmir, traced out the history of Kashmir relying on the contextual text of Rajtarangni and Bamzai's on culture and political history of Kashmir. Thereafter, I proceeded to analyze the circumstances in which Jammu and Kashmir Constitution Act of 1939 came into being, and then considered the submissions under different heads. Read out my conclusion. More or less, the conclusions are same, except in one of the aspects of Prerna's Call's case, I have taken a slightly different route. That's all. So, the relationship between Union and State of Jammu and Kashmir, the concept of internal sovereignty after the IO. I am of the view that this question has been decided by the coordinate bench of this court in Premnath Call that the state did not lose all semblance of its internal sovereignty, which would include deciding upon the forms of government of the state upon signing of the IO. The distinguishing feature as compared to the other states was that a slightly different path was followed for the accession of state of Jammu and Kashmir by recognizing the Constituent Assembly to be formed for the state. The route of assimilation of state of Jammu and Kashmir was through Article 370. Then I've heard that I've taken note of the various factors such as Article 370's historical context in the text and subsequent practice to conclude that Article 370 was intended to be a temporary provision. As a corollary, there was a mechanism to bring the whole arrangement to an end. The effect of the power under Article 373, once exercised, would be that the article shall cease to be operative. In other words, the mechanism was meant to de-recognize the state's internal sovereignty Thus, the exercise of power under Article 373 meant that for purposes of the Constitution of India, only the Constitution of India would apply to the Jammu and Kashmir and not any other constitution, that is the Constitution of Jammu and Kashmir. The purpose, then on Article 373, I've said, the purpose of the Constituent Assembly was to draft a constitution for the governance of the state. On the other hand, the purpose of Article 370, as noted above, was to slowly bring Jammu and Kashmir on par with the states in India. It can hardly be contended that the second and in some ways a larger purpose would be effected by the fulfillment of the first. The second purpose remained an ongoing exercise long after the State Constituent Assembly was dissolved. Thus, the conditionality in Article 373 of the requirement of a recommendation from Constituent Assembly cannot be read in the manner as to make the reference to the larger intention of the provision redundant. B. The next question is to determine what process is to be followed by the President to exercise the power under Article 373. The President can exercise this power under subclause 3 without a recommendation from the Jammu and Kashmir Constituent Assembly. When the Constituent Assembly ceased to exist, only the power of the Constituent Assembly to make the recommendation ceased to exist. That is, the proviso to Article 370 became otious. The main provision, which is the President's power to issue a declaration, continues to exist. C. Now coming to the impugned action, first the amendment of Article 373 through the route of Article 367 was invalid. When a methodology has been provided, that methodology would have to be followed and an amendment through the back door would be impossible. D. Concurrence with the government of the state was not necessary to apply all provisions of the Constitution of India to the state. Although Article 371D requires concurrence with government of the state, in this case, the governor of the state had dissolved the Legislative Assembly of the state. There were no council of ministers, and the president had reduced to himself all functions of the government of the state under the 2018 proclamation as extended. Then on the exercise of power under Article 356 were permissible while issuing COs 272 and 273. Article 356 can be imposed once the Legislative Assembly has been dissolved, particularly since Section 92 of the Jammu and Kashmir Constitution limited the governor's role to 6 months without any scope to extend. This imposition was predicated on the failure of the constitutional machinery, which really took place prior to the government's rules. Then B, Article 356 permits the President to make irreversible changes. Both Savanjay and Reddy J and S.R. Momai recognize that irreversible actions in this case, the de-operationalization of Article 370 is permitted if the proclamation had been approved by the Parliament prior to such irreversible action. C, the President reserves both legislative and non-legislative powers after the proclamation of emergency. Though Article 356 is continuance of Article 356, the former does not stipulate any bar or restriction on the Union Parliament or the President to exercise non-legislative power of the state legislature. Now, dealt with the challenge to Section 3 and 4 of the Jammu and Kashmir Reorganization Act. A, the challenge to Section 3 of the Jammu and Kashmir Reorganization Act on the touchstone of Article 3 is not required to be debated on account of the assurance on behalf of the Government of India that statehood of Jammu and Kashmir would be restored on elections being held. B, it is imperative to ascertain the views of the state legislature under the first proviso to Article 3 if the proposed bill affects the area, boundaries, or name of the state. However, in the instance case, since state of Jammu and Kashmir was under President's rule and the state legislature was already dissolved, the functions of the state legislature were performed by the Union Parliament. Hence, it was not possible to ascertain the views of the state legislature. It follows that Section 3 of the Reorganization Act is valid. I have penned down an epilogue at the end of the judgment, maybe some sentiments involved. The Valley of Kashmir carries a historical burden. It has a social context. Thus, in involving constitutional status of the region, it is difficult to segregate the aforesaid. We, the people of Jammu and Kashmir, are at the heart of the debate. They have carried the burden of victims of conflict for several decades, originating from 1947 with the invasion of the Valley. Intervening political circumstances did not permit a redressal to the fullest extent of the invasion. The consequences remain in terms of parts of Kashmir being occupied by other countries. The second round of insurgency holds its origin to the latter part of 1980s. There were troubled situations at the ground level, which was apparently not redressed. It culminated in the migration of one part of the population of the state in 1989-90. It is something that our country has had to live with, and without any redressal for the people who had to leave their homes and hearth. It was not a voluntary migration. The situation became so aggravated that the very integrity and sovereignty of our country was endangered, and the army had to be called in. Armies are meant to fight battles with enemies of the state and not really to control the law and order situation within the state. But then these were peculiar times. The entry of the army created its own ground realities in their endeavor to preserve the integrity of the state and the nation against foreign incursions. The men, women, and children of the state have paid a heavy price. During my travels home over the years, I have absorbed that the social fabric waning and the consequences of intergenerational trauma on the already fractured society. I cannot help but feel anguished of what the people of the region have experienced, and I am constrained to write this epilogue. In order to move forward, the wounds need healing. What is at stake is not simply preventing the recurrence of injustice, but the burden of restoring the region's social fabric to what it historically has been based: coexistence, tolerance, and mutual respect. It is worth noting that even the partition of India in 1947 did not impair Jammu and Kashmir communal and social harmony. In this context, Mahatma Gandhi is famously quoted to have said that Kashmir was a ray of hope for humanity. The first step towards this is to achieve a collective understanding of the human rights violations perpetuated both by state and non state actors against the people of this region. There have been numerous reports documenting these incidents over the years. Yet, what is lacking is a commonly accepted narrative of what has happened, or in other words, a collective telling of the truth. Internationally, the right of victims of human rights violation and the truth is an end itself. It encompasses a structural investigation of the events and social political structures that led to the atrocity, the particular circumstances of individual suffering, and an authoritative reporting of the results of the investigation. Additionally, truth telling provides an opportunity for victims to narrate their stories, which facilitates an acknowledgement from those responsible for perpetuating the wrong and from the society as a whole. This paves the way for reconciliation. While there are different ways of achieving these objectives, Truth and Reconciliation Commissions have been particularly effective globally. South Africa Truth and Reconciliation Commission was set up to investigate human rights violations perpetuated during the period of apartheid regime. It served as a mean of reckoning or a catharsis for victims and fostered peace building. Reflecting on its success, Albie Sachs J. noticed, as a result of the TRC, the private sorrow and grief of tens of thousands was publicly acknowledged to an embracing and personalized way. Another form of acknowledgement emerged from perpetrators themselves. They had to come forward openly in front of the television cameras, owning up their crimes. Finally, there was acknowledgement by the whole country that these things have happened and can happen again, that we needed to fit all these facts together in some kind of significant pattern, which would enable us to understand their genesis and do what we could do to minimize any possibility of their reoccurrence. In the past, calls for setting up of truth and reconciliation commissions have also been echoed by different sections of the valley. In view of the inroads made globally and indigenous request for truth and reconciliation, I recommend the setting up of an impartial Truth and Reconciliation Commission. The commission will investigate and report on the violation of human rights both by the state and non-state actors perpetrated in the Jammu and Kashmir at least since 1980s and recommend measures for reconciliation. The commission should be set up expeditiously before memory escapes. The exercise should be time bound. There is already an entire generation of youth that has grown up with a feeling of distrust, and it is to them that we owe the greatest day of reparation. At the same time, considering the significance of the matter and under sensitivities involved, it is my view that it is for the government to devise the manner in which it should be set up and to determine the best way forward for the Commission. I am alive to the challenges of recommending of the setting up of the Truth and Reconciliation is beyond the realm of the court. However, I am of the view that transitional justice and its constituents are facets of transformative constitutionalism. Globally, constitutionalism has evolved to encompass the responsibility of both state and non-state actors with respect to human rights violations. This includes the duty to take reasonable steps to carry out investigation of violations. It is this context that the proposed Truth and Reconciliation Commission accords with constitutionalism. Our constitution is no different and is designed to ensure that courts offer justice in situations where fundamental rights have been violated. In doing justice historically, our courts have been sensitive to the social demands of our polity and have offered flexible remedies. In Vishaka and others versus the state of Rajasthan, this court issued guidelines to address the workplace sexual harassment in the absence of an enacted law, which operated until the Parliament enacted the Sexual Harassment of Women Act. As a word of caution, the Commission, once constituted, should not turn into a criminal court and must instead follow a humanized and a personalized process, enabling people to share what they have been through uninhibitedly. It should be based on a dialogue, allowing for different viewpoints and inputs from all sides. In this context of South Africa's Truth and Reconciliation Commissions, Helbe Sachs observed, "Judges do not cry. Archbishop Tutu cried. It was not a court of law in the sense of an austere institution making a highly formalized finding. It was an intensely human and personalized body there to hear in an appropriately dignified setting up what people had been through. There were comforters sitting next to the witnesses. In a court of law, no one is there to help the witness, to pat the shoulder or provide water or tissues when the person weeps. Frequently, the sessions would start with a song in a beautiful African harmony, intended to give a sense of encouragement and support to everybody present. Or it could begin with prayers, and therefore, people spoke and spoke in all regions and in all languages of the country. The testimony was televised, and thus the nation became witness to what has happened and heard the stories directly from the mouths of persons concerned. Those who spoke were not complainants in court, denouncing accused persons in the dock, nor were the litigants demanding damages for themselves, so that the greater the loss, the greater the sum would be received. Taking a leaf out of the South African book, The Principle of Ubuntu, or The Art of Humanity and Inclusiveness should be central to the process. This will facilitate a reparative approach that enables forgiveness for the wounds of the past and forms the basis of achieving a shared national identity. Needless to say, the Commission is only one of the many avenues towards the goal of systematic reforms. It is my sincere hope that much will be achieved when Kashmir opens their hearts to embracing the past and facilitating the people who were compelled to migrate to come back with dignity. Whatever has been, but the future is ours to see.
A judgment is a decision which gives reasons to arrive at and reach a conclusion. By that stretch, my order is not a judgment. We have only two judgments. Both judgments are in seritum, and seritum and uniformly agree that Article 370 of the Constitution of India was a feature of asymmetric federalism and not sovereignty. Article 370 was enacted as a temporary provision and did not have a permanent character. The abrogation of Article 370 does not negate the federal structure, as citizens living in Jammu and Kashmir do and will enjoy the same status and rights as given to citizens residing in other parts of the country. Paragraph 2 of CO 272, by which Article 370 was amended by taking recourse to Article 367, is ultra-virus and bad in law, albeit it can be sustained in view of corresponding power under Article 371D. More importantly, Article 370 has been made inoperative in terms of Clause 3 to Article 370. Lastly, CO 373 is valid. I have agreed with what Justice Chandrachud has said, Chief Justice has said with regard to Article 356 of the Constitution of India. I have also made reference to Rameshwar Prasad and others versus Union of India and others, with which I respectfully agree. I also agree with the conclusions recorded by Dr. DY Chandrachud, taking record of the statement made on behalf of the Union of India for restoration of the statehood of Union Territory of Jammu and Kashmir while upholding creation of Union Territory of Ladakh. Then I have agreed with Justice Call with regard to interpretation on Article 370, Clause 3.